Hey everybody, welcome back to Thursday night. John Skiba here from the Consumer Warrior YouTube channel. Great to be with you once again here in the month of February. Man, it feels like it's already getting to be summertime in the great state of Arizona. We're going to be mid 80s next week, high 80s next week. So I can tell it's summertime though because I'm getting more daylight. It's not dark anymore when we're doing the live stream. So my name is John Skiba, and I am founder of this Consumer Warrior YouTube channel. Been doing this for about 11 years, this YouTube channel. And each and every Thursday night, try to do a live stream to really talk about things you want to talk about. Questions related to bankruptcy, debt collection lawsuits, wage garnishments, all the other horrible debt-related things out there. I try to offer some information, some insight, maybe point you in the right direction. If you need legal advice, you should find an attorney. I am a licensed attorney. I am the founder of the Arizona Consumer Law Group here in the Phoenix, Arizona area. And so if you need help, this is my information below. There's also a link in the chat section where you can set up a consultation where you can get help from an attorney for bankruptcy, debt collection lawsuits, all the other stuff we talk about here. Click on the link. You can schedule the appointment. It's pretty quick. Or if you're in Arizona, give a call to the number. You can click the link if you're in Arizona as well. But otherwise, just give the number a call. So the title I put on today's live stream is Debt Settlement or Bankruptcy. And I wanted to talk about this because I've got this question quite a bit lately here in my practice in Arizona. People asking me like, hey, John, what's your honest opinion? Here's my situation. I'm dealing with these types of debts. This is how much debt I have. Should I just try to settle these out? You know, kind of Dave Ramsey it, debt snowball kind of thing, or should I look at the bankruptcy option? And I always give kind of the unsatisfying lawyer answer, well, it depends, because it does depend. It depends on a lot of different things. There's no bright line rule. You know, a lot of times people say, you know, do I have enough debt to file for bankruptcy? It kind of depends on your ability to repay the debt. You know, I've had clients with over $100,000 of credit card debt where we've sat down and looked at it and said, you know what? You could probably knock this out, settle this thing out within a year or two, and then be done. You don't need the bankruptcy. I have filed Chapter 7 bankruptcies for people with $10,000 of debt because the way of their income, their employment situation, and just overall life situation, there was no way they were going to be able to pay that back. Also, things that influence whether you should file a bankruptcy or not are really the stage as far as where the collections are at. If you have something where you're current on your payments or you just barely missed a payment, but you still think you can get it brought current, then maybe it's not such a crisis as compared to if they're filing lawsuits, debt collection, as far as like wage garnishment, all that kind of stuff. If they're going to garnish your wages, even if maybe it's a lower amount, maybe that wage garnishment is going to really make it so you're not going to be able to afford the basics, then maybe a bankruptcy is also the better route to go because that'll stop that wage garnishment right from the get-go. You also need to look at factors like if you qualify. You know, we've talked about before, like Chapter 7 bankruptcy, you actually have to qualify for it for an individual in Arizona, and this is based on a state-to-state numbers, and it changes periodically. I'm recording this in February of 2025, and the cutoff for an individual in Arizona is right now $68,000 a year, roughly. If you make $68,000 a year or less, you automatically qualify and you can file a Chapter 7. Household of 2 is about $83,000. Household of 3 is $99,000 a year. Household of 4 is $110,000 a year. It kind of keeps going up. Sometimes you're in a situation where there's this overwhelming debt issue, and maybe your income has been way higher before, but there's been a job loss or a medical issue that's made it so your income has gone down. I always say sometimes there's this window kind of opportunity. If you're going to do a Chapter 7, that's when you need to do it. So those are the kind of factors I look at, which again, I know it's nice when there's just a real bright line thing saying, yeah, if you make X amount and you have this much debt, bankruptcy, or this amount debt settlement. I also, one last thing I'll bring up is the number of creditors you have. Sometimes I have people call me and say, hey, I want to try to settle out this various claims that I have, and they have like 18 credit cards. Usually I start leaning more towards bankruptcy just because it's difficult to get all 18 companies on board, all these banks and lenders. And I always say, you know, if you get half of them settled, great, but then you got 9 who are going to sue you. So those are the kind of factors you should look at if you are looking as far as settlement, bankruptcy. looking at assets, if you have certain assets that you may be at risk of losing, those are the kinds of things that you need to think about. So, all right. So here's how we do this. If you have a question, put it in the show note or in the comment section or in the comments over at Facebook. Put it in there. I'll put it up on the screen. We'll talk about it. Again, you have to give the lawyerly disclaimer. Don't take this as legal advice. Some guy talking on YouTube, so take it for what it's worth. If you need an attorney, what do you call it? Go ahead and check down below. So, all right, let's see here. Matt was here nice and early. We'll jump into the Matt. Matt says PRA, which is Portfolio Recovery Associates at LBNV and Midland, accounts are set to fall off reports in middle end of 2026 because of DOFD. We're in 2019. Should I wait it out? Or will any settle for 25%? If I settle, will I get a 1099? So, okay, a couple things to unpack there. So statute of limitations is going to expire, or they're going to fall off the credit reports at least. I guess that's the kind of question we need to look at. Is the statute of limitations going to expire, meaning they can't sue you anymore, or is it just going to fall off your credit report? Because falling off the credit report, that alone, I mean, sometimes they can still sue even if it's fallen off the credit report, even though it's usually about 7 years. Most statute of limitations throughout the country are less than 7 years, although I believe there's a few that are 10. So should you wait it out? The issue that you need to look at, the longer that a delinquent account is on a credit report, the less overall impact it has. So if you fall behind on a credit card during that first year, it's going to have a huge impact on your score, whereas on year 6, it's not. So I think that's one consideration. Will they settle for 25% or less? You can reach out. It doesn't hurt to offer in general. Settlement offers in civil, like lawsuits, can't be used against you. You could reach out and see what they're willing to do. If it's really that close to falling off of everything, it's unlikely, in my experience, that you're going to get sued by it. If lawsuits happen, they usually happen in the first 1 to 4 years is where I see it. If it's been out there longer than that, it's unlikely. The 1099. So the 1099-C is something you get when a creditor forgives debt. So, for example, if you have a $20,000 credit card, you negotiate with them and you're a shrewd negotiator, you get an $8,000 settlement. So you pay them $8,000. The creditor agrees to forgive $12,000 of that. Fast forward 1 year, in the January of the following year, you're likely to get a 1099-C. Now, what that is it's them saying, hey, and the law requires them to do this. We forgave $12,000 of this. And so the law requires you to count that as income when you file your taxes. And so it's almost like you added $12,000 of income on top of what you already made from your job. And then you could be liable for taxes on that. Now, it's outside the scope of what I do as far as tax liability there. There are ways around that. I know if you're technically insolvent, if your debts are greater than your assets, there may be no liability there. But if you get a big 1099-C, it's always worth talking to a CPA or an accountant when you do your taxes to determine if, how much it's going to impact you. I do say, pretty good with large accounts, it's better to pay taxes on $12,000 than it is to pay $12,000. But it may impact overall things like refunds and your ability to, as far as what you end up actually owing, as far as taxes in full. All right, let's see here. Shanita says, did you read the ACLU report where debt collectors had debtors arrested for their debt? I haven't read the report. I've seen the horror stories out there. I've had clients before where you get these rogue debt collectors who threaten things like jail. Jail, with one or two exceptions, is not on the table for debt collection. Debtors' prisons were outlawed in the U.S. like in the 1830s, I think. So they've been gone for a while. But what debt collectors will do is that they'll, if you're in a situation where the debt's overwhelming, these collectors are calling, it's stressful, you're often not able to, you're not making ends meet right now. And then all of a sudden, they can kind of play on that. And they can also put a lot of pressure on you where you're worried. If you're not quite sure, is that true or not? Am I going to go to jail over this? Maybe you'll pay something that otherwise is outside the statute or may not even be yours, or the balance might not be correct. Debt collectors, you see less and less of that. There's a law called the Fair Debt Collection Practices Act that says what debt collectors can and can't say. the reputable debt collectors, if there is such a thing, that's just a joke. There's ones that do good jobs, but the reputable debt collectors that are the big, who do this on a huge scale, you're not going to hear that kind of garbage as far as, because they know that the liability is huge. That's a slam dunk. You're going to be able to sue them, get money. The debt's going to go away, and they're going to write you a check. On the other hand, some of these kind of low-level debt buyers, scam artists, they will do things like that. Like the client I had, they would call up and they'd say, "Hey, we're outside. This is the sheriff's department. We're here to arrest you unless you make a payment right now." And, the client is freaking them out. One, they're saying they're right outside their door. They're at your house. It really feels invasive as far as what they're doing. And they weren't. They were across the country just doing this kind of garbage. But what I found is there's kind of this sliding scale as far as extreme conduct like that. Those debt collectors are often very difficult to find because they're not legitimate. They're not companies that are actually running a business. They go out, buy some paper, and then make calls and threaten people and hope to get a quick buck on it. So, all right. Joe says, what are the cons after Chapter 7 bankruptcy? The biggest one's the hit to your credit. Most people see about 100 to 150 point drop when the case is filed with the court. It does stay on your credit report for 10 years. There's a public records section on your credit report that where it used to be that judgments and tax liens and things like that would show up. 2017, they changed the law. So now those types of things don't show up anymore, but a bankruptcy will. So it'll say, bankruptcy, District of Arizona, state the date that it was filed or discharged. And then the creditors on your credit report will still be there, but the amount owed will be zeroed out. And there's likely going to be a little notation on the side saying it was discharged in a bankruptcy. Most people recover fairly quickly. It's on there for 10 years. But like FHA, VA, they'll do normal mortgage loans again 2 years after the bankruptcy case is discharged. Some lenders are 3, some lenders are 4. I have routinely had clients get mortgage loans with normal interest rates 2 years after a Chapter 7. Car loans and credit card type things are available almost immediately. Clients tell us we file the case and then 2 weeks later our mailbox is like full of car loan advertisements and credit card advertisements. You're just not going to get good interest rates until you get further away from that filing date. So, but for most people, the biggest downside is going to be that credit hit, which you will recover from, though, usually around that 2-year mark. 2 to 3 years, you should fully recover from that. All right, this one here says, so with LVNB, even though they filed a lawsuit in the wrong venue, I still filed an answer with that court. Can I still file for a motion of dismissal with prejudice? Good question. Can you do it? Yes. Is the court going to grant it? Probably. In my experience, there is some law out there, some case law, at least in the state of Arizona. If you file an answer in the lawsuit, then technically you essentially you've waived that argument. You've waived the ability to argue that venue is improper. So that may be a problem. The court could say, well, you filed an answer. I mean, the procedurally, the better way to go would be to file a motion to dismiss with the court instead of an answer, because by filing an answer, you consented to jurisdiction and a venue. At least that's what the argument is. So that's something you may want. You can still do it, though. Like I said, there's always the thing, can you do this? You can do it, almost anything. The question is if it's going to be granted, and that sometimes you don't know. So, hey, I'm just going to throw in there the link one more time. If you're looking for bankruptcy legal help, this is a way to set up a consultation. I'll throw that in the chat section. All right, let's see. Andrew, how are you doing? If my Chapter 7 is not discharged, what happens to the reaffirmation agreement for my vehicle and my home? So reaffirmation agreements they're kind of just this convoluted mess. This is something that changed when the bankruptcy code changed back in 2005. They added this extra layer of these reaffirmation agreements. And what it is it applies specifically to car loans. So if you file a Chapter 7 bankruptcy and you owe money on a car, you want to keep that car, the court says you need to go ahead and complete a reaffirmation agreement. The reaffirmation agreement is filled out after the bankruptcy case is filed. The creditor provides it usually to your attorney. And then if you have to be on time on the car loan payments, and then they'll send it over. And basically, if you sign off on it, what you're saying is, okay, I'm agreeing to continue to pay on this particular loan and be held liable for it going forward. Now, the reaffirmation agreement requires three things. It requires you to sign it. Your attorney can sign it, but the court has to approve it, and the creditor does. Maybe that's four things. The creditor has to. So you have to sign it, the creditor has to sign it, and then the court has to approve it. And often in Arizona, I can tell you the courts are not real big fans of the reaffirmation agreement. Here's why. If the court approves a reaffirmation agreement, let's say you owe $30,000 on the car loan, you're going along, it's fine, you're making the payment, you get the reaffirmation approved in your bankruptcy, and then a year down the road, you lose your job or you get in a car accident and something. Anyways, the car is done. You can't drive it, or if you've lost your job, you can't pay for it, and you got to let the car go back. If the court has approved the reaffirmation agreement, then you're liable for any deficiency balance. So they come repo the car, they sell it at auction, they get next to nothing for the darn thing, and then you're liable for the balance. They can sue you, they can come after you, and it's not a great situation. That's a big, kind of what if, but it happens. It happens frequently where something happens down the road and the car ends up going back, and then you'll be held liable for it. However, if the court does not approve the reaffirmation agreement, or if you don't sign a reaffirmation agreement, as long as you're making the payments on the car, you can keep the vehicle. But if that scenario were to happen where the car got in an accident or you couldn't make the payments anymore and they repossessed it, they could take the car back because they have lien rights in your vehicle. They could take the car back, sell it, but that's all the money they would get. They couldn't come after you for the balance. So, and clients often wonder, why does it take me so long? Because the whole process is kind of screwy. It takes a long time to fully explain it. It always doesn't make a ton of sense. But so often in Arizona, what the judges will do here, even if you sign a reaffirmation agreement, they often don't approve it. And they just tell you, go ahead, keep making your payments. That way, if something happens down the road, you're not liable for the balance on that vehicle. So why would anyone want a reaffirmation agreement to be approved? The big kicker is, and this is probably really the only reason why you'd want a reaffirmation agreement approved, is because if you don't have an approved reaffirmation agreement, the creditor is not obligated and they will not report any information to the credit reporting agencies, good or bad. So if you're making on-time payments, it's not going to show up on your credit report. It's not going to show up as anything. They're not saying you're late. They're not saying anything. They're just saying that there is no activity on it. So a lot of people are really concerned about that because they want to, rebuild the credit. I can tell you that there have been, both in California and in Arizona, bankruptcy courts, they've actually held kind of like trials where they actually had people from the creditors come in from Experian, TransUnion, Equifax, the big credit reports, to get expert opinions on what kind of bump after a bankruptcy a reaffirmed loan on a car is actually going to do. Most of them have said the positive impact of those on-time payments is almost nothing, which seems backwards. And I agree. I admit it. I understand that, but I'm just telling you that's what they have said. And that's why in Arizona, particularly, the courts typically do not approve those reaffirmation agreements unless, there's some factors. If you're pushing for it, your attorney's pushing for it, then they will. Now, mortgage loans it's the exact same thing. Sometimes there's a bigger risk. I only practice in Arizona. Arizona has something called an anti-deficiency statute that protects you. So sometimes the judges will sign off on those, but there is some risk there. So it's, that's something I always go over with all my clients when it comes to reaffirming a car loan or mortgage loan, is you can do it in the Chapter 7. There's some upside on the credit reporting. There's also some downside on the potential liability down the road. So, all right, let's see here. Joe had another question. Is there a judgment against you? Do you disappear with the Chapter 7? So if you file Chapter 7, yes, the debt associated with the judgment will go away. The judgment will become uncollectible. And even if they've recorded the judgment against your home, it may be possible because if they record it, it acts as a lien against your home. If they do that, it's possible to file a motion to void that lien if it encroaches on your homestead exemption. So that's something you want to talk to an attorney about for sure. But yeah, typically in Chapter 7, you're able to typically get those things out. So let's see here. Melter says, hello, I just filed for Chapter 7 bankruptcy. I just had the creditors meeting yesterday. I wonder when you can start fixing my credit now before the bankruptcy discharges. Typically, so the way that the Chapter 7 works is you file the case. About 6 weeks later, you have the meeting of the creditors, which is your meeting with the bankruptcy trustee. And then usually about 60 to 90 days after that, the bankruptcy court, the judge will sign the discharge order, which gets rid of the debts and ends it. Typically, your credit is not going to do a whole lot until that discharge order is entered. The reason why is because once the bankruptcy judge enters the discharge order, it usually takes about 30 to 60 days, 1 to 2 reporting cycles for the credit reporting agencies to receive that discharge order, go in there and zero out all the debts that are on the credit report. And then that's when you'll see a bump. Usually, soon after the discharge, you'll start to see the credit score go up. So usually there's not a whole lot you can do during the bankruptcy. You're not supposed to be incurring new debts or anything like that while you're in bankruptcy. So I usually say, Chapter 7, relatively short process. The score will go up naturally, even within the first 12 months. So probably just to be patient, it'll happen there pretty quick. So, all right, let's see here. Roger Dodger says, hi, John. When you pull someone's credit report, does it accurately show who currently owns their debts and exactly how much they owe on their debts? If a debt has been sold several times, various debt buyers, various debt buyers, how do you identify exactly who you'll need to deal with to settle the debt? This is a good question. It's harder than you might think to be able to find out who has the stinking account, because something that surprises a lot of people, the creditors are not required to report at all on your credit report. I often run into this kind of battle with creditors when we're trying to negotiate a settlement. We try to do the pay for delete thing. Hey, we'll pay the settlement, but you got to delete it off the credit report. And they'll push back and say, no, the Fair Credit Reporting Act says we have to report accurately. So we're going to report that the thing was settled. I always counter with that. Hey, there's no obligation for you to report at all. Creditors do that voluntarily. It's not something the law says, hey, every one of you have to report on the credit to the credit reporting agencies. The credit reporting agencies, they feel like these, kind of quasi-governmental entities because they have such a big impact in our lives, but they're just private companies. They kind of work together with lenders and that so that they can determine who's creditworthy. There's no requirement that they file at all. And so because of that, to your question, yeah, sometimes you can look, like on Credit Karma, or you can actually go to TransUnion, Equifax, Experian. You can see who's on your credit report. Really quick, a good free resource is freeannualcreditreport.com. That is a government-sponsored website where you're entitled to pull a free copy of your credit report. Typically doesn't have the scores on it, but you can see the creditors. That may be a place to start because you can print that out and see exactly who's on there so you know who to deal with. But I can tell you some debt buyers do report on the credit report. A lot of them don't, particularly lower level ones do not report at all. I know just in talking to their attorneys, they feel like it's a mess. It's a trap. It's a trap, the credit report, because if they don't report accurately, attorneys like me beat them up over it. So, yeah. So sometimes it's helpful. Sometimes it's not. Sometimes you just have to just sit on the phone. I have that. I'm dealing with the debt settlement right now where, I call and I get this phone tree where they transfer me 10 times till we get to the most current holder of the debt. So, all right, let's see here. Going back to, so you're asking, did you waive your right, even though I stated improper venue? Okay, if you did list it in your affirmative defenses, first of all, that's next level stuff. Nice job. Yes, you go ahead and file your motion. So the affirmative defense essentially reserves that right. Procedurally, you probably still should have filed a motion to dismiss, but if you listed it in the affirmative defense, My guess is the court may overlook that, and you'll want to point that out in your motion to dismiss. Hey, I reserve this right. The affirmative defense. So when you file your answer to the court, if you get sued, you're just responding paragraph by paragraph to the various allegations of the creditor. The affirmative defenses that you put at the end, a good way to think of those. So affirmative defenses are kind of equivalent, like in criminal law. Let's say that you have a defense where even if I'm charged with murder, John Skiba is charged with murder, and then and we say, yeah, I did that, but it was self-defense, or it was insanity. So basically you're saying, even if everything that they're alleging against me is true, I have a defense, and that is self-defense, that I was just defending myself. And so I shouldn't be found guilty. Well, in the civil world, affirmative defenses are something similar, where like I often will allege statute of limitations. That way we're saying, look, even if everything that's in that complaint is accurate, statute of limitations expired, so they're not able to come after me. So that's kind of a easier way to think about those. So let's see here. Joe Nobody has a question. Hi, John. Does MCM, also known as Midland Credit Management, ever sell their junk debt purchased from Citi cards to other junk debt buyers? They said they wouldn't sue, although not past the statute of limitations. Might have documents, probably why they won't sue. But sue me, but concerned they might sell to somebody else. Still 3.5 years left before the statute of limitations. Thanks. I have not seen Midland sell their debt. From my experience, I've been doing this 22 years now. I don't know if I've ever seen an account. I mean, I've seen Midland Funding sell it to Midland Credit. I may have seen one go, to some of their sister companies, things like that, companies that are all part of the same umbrella. But I don't usually see them sell it to, Midland sells a debt over to Portfolio Recovery. I usually, so Encore Capital is parent company of Midland Funding and Midland Credit. It's usually the end of the road. They usually take it, they sell it, they usually collect on it, or it's just done, that kind of thing. So, all right. Joe E says, this may be off topic, but have you ever talked about the questions the trustee will ask you at the meeting? Do you have a video covering that topic? I have a video for my clients. I'm trying to think if I have a video for, I do internal videos for the clients I work with here in Arizona, but I can go over it real quick, and it'll be different from state to state. I mean, there are some general questions they're going to ask everybody. In Arizona, they ask basically the same basic questions. They're going to ask you, one, if you have lived in the state of Arizona for at least 2 years. They're going to ask you if you filed any prior bankruptcy cases in the last 8 years. They're going to ask you if you reviewed your bankruptcy documents prior to filing them, if you signed off on them, if you included all your creditors, if you included all your assets. They're going to ask you if you have any ability to, if you expect to receive an inheritance, or if you have any type of personal injury claim where you expect to receive monies in the future. And then if they have anything specific about your case, they'll bring it up at that point. The meeting of creditors in a Chapter 7 bankruptcy is very short in most cases. It's called the meeting of creditors. The number of creditors that have appeared at hearings that I've been at, and I've done thousands of these, I can count on two hands. Maybe 10 times a creditor shows up. It's very rarely happens. Usually because most institutional creditors realize, the trustee is going to give you maybe 5 minutes, and they have other avenues. If they want to ask you questions, they can just go to your attorney. They can set up something called a 2004 exam, which is like a deposition. So there's other ways that they can deal with it. So in and of itself, it's usually pretty short. Sometimes if there's assets, they'll ask for additional documents. Across the nation now, all the meeting of creditors are done via Zoom, which is nice. In Phoenix, they used to be done down at the bankruptcy court in the Phoenix area, at other courthouses throughout the state. Now it's all done via Zoom. So it's, basically like watching a YouTube channel. So, all right. Gigi says, I received a 1099 something form from a creditor saying they forgive all the debt. Do I call the IRS to see? So that's what I was talking about before, the 1099-C. That means that they either forgave the entire amount, and so they're reporting to the IRS that they forgave it. So that's why it's important that you do bring it up, because when a creditor issues a 1099-C, they're also shipping a copy off to the IRS. So the IRS is aware of this. It's not like you can hide it and say, "Oh, I'm not going to let them know." They know. It's just a matter of you disclosing it. And again, I would if it's a large amount, if you get a 1099-C for $500, who cares? But if you get a 1099-C for $50,000 because they forgave a large debt, you may want to take a look at that with an accountant or a CPA. So, all right. Richard says, do I have clients in other states? So I'm only licensed in the state of Arizona. So I only have clients here. I do have kind of a network set up where other attorneys I can refer you to. I'm going to put the link in the comment section, Richard. If you click on that, just click on the call now or book now. They'll connect you with another attorney in another state who does exactly what I do. So, all right. Patricia says, John, the rent allocation for filing a Chapter 7 bankruptcy is $1,150. I am over by $600. How is that handled by the trustee? Okay, so good question, Patricia. What this is with the Chapter 7 case, I can tell you there's these income limits based upon household size. Again, in Arizona, for an individual, it's $68,000 a year. If you make less than that, you're in. It's a math problem. You don't have to do anything else. If you're over that, there are deductions that can be made. Part of what they look at in determining if you qualify is they give you essentially a budget based on these IRS national standards or an allocation here, like Patricia's talking about. And they base that upon your state, sometimes by county, as far as what the allocation is. She's saying here for her rent, it's $1,150, but her rent is $1,750. The trustee doesn't do anything. It's not like they make you move or anything like that. All that is it's kind of part of the math problem in determining if you're actually going to qualify for a Chapter 7. They're only going to let you deduct the $1,150, not the full $1,750 that you're paying each and every month, if that makes sense. So, because, I've had clients say, well, okay, I don't qualify because I make too much money. Well, what if my rent is $6,000 a month, or I have a car payment that's $2,500 a month? Doesn't matter. They're only going to allow you to deduct a certain portion of that based upon those national standards. So, all right. We'll do one more here. Coach Karen. She goes, I filed a DIFI against Chase, and they told me after 3 months to file with the OCC for a mortgage dispute that Chase falsified my income. And of course, they sold my mortgage. I'm lost. I might be lost too, Coach. That's a little, so particularly mortgage debts. I don't deal a lot with that. So I'm sorry, I'm not going to be much help there. But I'll research this when I come back. How about that? Put it in the comments. I'll research that and come back and try to give you some type of advice on that. So, all right. I think we'll just wrap. Well, I had a couple things from the channel. I like to touch on those just because I know some people tell me I put a question in the comments and you don't ever get to it. So, all right. This person said, I filed a motion to dismiss and compel arbitration. So we're dealing with the debt collection lawsuit. They said, hey, judge, we don't want to be in court. We're going to file for private arbitration and get this thing into private arbitration and out of the court system. There's still a trial date scheduled after the motion date. Does that indicate it will be denied? And what should I do to win at trial? Will they negotiate? Should I try to get an attorney, hopefully pro bono? So just because the trial date's still on there, filing the motion is not going to get rid of the trial date, only if it's granted. If they grant your motion to throw it into arbitration, then they'll remove that. The court's dockets are insane. It doesn't matter the court, where you're at. They fill up, I'm getting trials scheduled right now already in the fall. So this is February. We're recording this. We're getting trial dates September, October. If you're in Superior Court or even federal court, we're already in the 2026. So what they do is they're going to put a placeholder there, save that date just in case it's needed. And then if it gets pushed into arbitration, they'll get rid of it at that point. So negotiation can happen at any time. My mantra, they want money, you're offering money. There's got to be some middle ground that you can reach. So you just have to be persistent, keep going, keep working at it. You'll get something done. Should you hire an attorney pro bono? If you can get one, I think it's a great idea. I can tell you that it's kind of difficult to get civil cases pro bono. I mean, it just is. I mean, unless you go to like a legal aid society or something like that where they have funding. I can tell you, even like in my office here, all we do is consumer debt issues, bankruptcy issues. And, so a lot of times I'll get people who call and say, hey, I need to do a bankruptcy. Can you reduce the fee? Because I'm kind of in a financial tough spot. Unfortunately, everybody I deal with is struggling. That's just the nature of the business. And so I try to keep my fees reasonable, so I can pay for my staff and I can pay for my 6 kids and all that kind of stuff. But it's something where pro bono in the civil world is a little tough. I do some pro bono work and we'll do some reduced hours. It's kind of tough. So I would probably contact your local state bar. Sometimes they have a list of pro bono attorneys who have signed up to say, hey, I can do so many hours a month. Or like a legal aid society, they're going to definitely have people that can help you out. So do some follow-up here. Okay, this is if the judge does dismiss for improper venue, should I still sue for improper venue and other violations that I have seen from the FDCPA? If you feel that you have violations of the Fair Debt Collection Practices Act and suing in the wrong venue can be a basis for liability, it is something you can bring a lawsuit for. Often it results in cases, just either dismissal or some type of settlement where both parties release each other for all those kinds of things. So, I think that's something you might want to talk to an FDCPA attorney. I have done FDCPA cases. I don't do a lot of them, but most attorneys handle those cases on a contingency because the FDCPA does state that if you prevail, they got to pay your attorney's fees. So that makes attorneys a lot more willing to take those on that type of thing. So, all right. iMelter says, I have a car lease and I filed for Chapter 7. I don't want to keep the car. Is there a time to return the car or whenever I want? Okay, good question. So you filed bankruptcy, and this is whether it's a lease or you're buying a car. You can surrender the car through the bankruptcy, and then you won't owe anything on it going forward. Now, a little bit of it is local practice. Some you can actually call up and arrange for, to go drop it off at a dealership or have the lender come pick it up. Some lenders are a little nervous because when a bankruptcy case is filed, the court puts an order in place that stops all collections, including repossession, phone calls, letters. They can't call you and tell you to pay any kind of money. So sometimes they will file a motion for relief from the automatic stay. What that document is it's them saying, Judge, hey, Melter here wants us to pick up the car. We want to come get it, but we don't want to violate your order. Do we have permission to do that? That process takes, at least in Arizona, about 21 to 30 days to get that order. Most of my clients that surrender cars, it's done either very early on or maybe closer towards the end of the bankruptcy, a few months in. My advice is keep the car insured until you actually hand it off. So, okay, we will, excuse me. Let's see. We'll do one last one from the channel. This one says, what if you're already far behind on a car note and they have written it off? So, I have seen these kind of weird scenarios where car lenders will, payments aren't being made, but the car lender is not repossessing the car. I mean, we're talking years going by with no payments being made. I've even had bankruptcy cases, kind of like the last question, where they're like, hey, come get it. We're done with this car. And they're like, nope, we're not coming to get it, because they don't want to spend the money to hire a tow truck or whatever to try to sell it. It's just kind of a weird scenario. It's a lot of these buy here, finance here kind of places. Sometimes they'll do that. They're like, yeah, they just kind of abandon the car. The problem you run into is when you go to try to sell it, you still have your lien on the title. And so then you're going to have to go back and try to either negotiate or get something done where you can get that lien off. So the fact that they've written it off as a debt, or, we see this with credit cards too, where they charge it off, doesn't mean that the debt's still not owed. And with a car loan, it doesn't mean that the lien is gone. And so the problem's not solved. It's going to have to be dealt with eventually to get it squared away. So, all right. We've been going a little bit over, but hey, I appreciate, those are all great questions. Thank you all for checking in tonight. Appreciate that. I am going to, let's see here. I'll put that one more time, my link in there if you want to set up an appointment. If you're in Arizona, you'll talk to me. People sometimes say, oh, I'm actually going to talk to you. Yep, there's nobody else. I'm the only attorney here. So you'll talk to me about it. But even if you're not in Arizona, click on that. We can connect you with someone who who can help you out. Appreciate everybody checking in tonight. And with that, catch you next week.